Good evening, everyone. I welcome you all to this exciting Mr. Harit Mohan on IPR strategy for startups. The flow for the session today is a presentation by our guest speaker, followed by question and answer session. It is a pleasure to introduce Mr. Mohan this discussion forward. Mr. Harit Mohan is the founder and CEO of Signicent LLP in India and Signicent LLC in Delaware, USA. As an IIT Madras 2008 postgraduate, research and technology has always been close to his heart. He has also done course on entrepreneurship, launching an innovative business at University College Park. He has given 12 faced by research companies and institutes. He, with his services globally, has been a CI. Last year, I
Hello.
hello, sir, can you hear me?
Yeah, I think I lost you out completely in between. Uh,
Oh,
I
all right.
didn't hear the last part. If everybody says, should we
I'll
begin?
yes, absolutely. If you can do that.
Okay. Okay. All right. Uh, I have shared my presentation deck. I hope you can see it.
Yes, sir, we can see it. We can see it.
Perfect. Thanks a lot, everybody for giving me this opportunity to talk to you about the intellectual property strategies for startups. To give you a little introduction, uh, I have been actually working in this space for about 12 years. Before that, I studied from IIT Madras. My majors was in biotechnology. However, the company that I run today deals in multiple areas, which includes just not biotech, but we do a lot of consultancy in almost all the areas. Startups have been close. I've been doing a lot of sessions with startups. I've been mentoring some startups also in the last few years. So IPM startups are basically something that are very close to me, and I've tried the next 60 minutes. I'll try and make sure that I can give you some more idea on how things work from both the perspectives. All right. The first thing that we would be, sharing about today would be on the area of IP. And as I said, so I started off this company 8 years back. So a little introduction before we start deep diving into the presentation deck. From here, you would see that we've been located in India and in US, and we have currently an 80-member team who are all researchers who help us in IP and market strategies. And let's start with the first and the important thing over here, which is ideation. Now, what we need to understand is every startup is basically looking for an idea that they could kind of work upon, and ideation remains the major and the basic step that everybody would like to know that where do we start? What's the beginning? What's the first point? So everybody kind of wants to step into that first step, and they want to understand that, okay, if you're going to take this step, what should that be? Which area should that be? Can I take some calculated risk? Where are the white spaces where I could earn money? All this is possible if we do good R&D, and if we understand that how we could go into that area. So of course there is no one way to do it. There are several possible ways you can do ideation. But these are my favorites that I'm sharing you in the screen now. So the first thing is read a lot. Okay, what we have seen is, or what I have seen in my life is that probably nothing gives you more edge than reading a lot about the area that you want to build in. This could be both from the technical perspective as well as the challenges you may be facing right now in running these startups. And the second important thing is whatever idea that you are thinking, or at least whatever area that you are thinking you want to go into, you need to understand that instead, in addition to reading, probably web is considered as a big thing and you get a lot of data there. Understand a lot of data before even you make your first move. You need to make sure that you have a good knowledge of the prior art. That's the word that is used in IP industry. So you should have a very good idea of the prior arts that are available and how things are moving in that area. Next is in the observation space. So you have to observe a lot. I'll give you a very simple example. So, for example, yesterday I wanted to charge my mobile phone and I wanted to keep it close enough because I was using my hotspot connection and my battery was dying. So the switch that I had for charging point doesn't have a table nearby where I could put my phone on it. And what we generally then do is we kind of balance our mobile phones on the head, on the charging head, and pray that it doesn't vibrate and press down. But that happens a lot. And I'm sure most of you who are listening would have tried this at least once of trying to balance your mobile phone on the head of your charger if it is big enough. And would have easily fallen down and could have given you damages. So this is a that we have. Instead of looking away at it, or instead of looking for the solutions that are available, what we generally do is we need to start off finding solutions of this small problem. And then we need to understand the market potential, market size, something innovative. So, small observation, I would say, and should not make such day-to-day problems. Next, what happens is that unless you write that idea down somewhere, how many times will happen that I'm thinking something and next 15 minutes it's gone, and probably it's gone forever. So, I, for example, make sure that I have a to do, what's the next idea, what I want to develop. So that's another thing that I've recommended, and it actually gives a lot of good results. If you keep writing, especially the ideas, be it incremental ideas or something that you want to do, keep doing that. Last is do a lot of networking. Now this is something that I started in my career a lot late. Probably, we always think that we're entrepreneurs and we know almost everything. What I've realized is a lot of times the ideas that the startups want to work with, they have it, but to make it practical or to make it solutionized, they need to talk to people who have done that before. So if you are, let's say, in manufacturing space, talking to somebody in food technology could give you a solution which could have a use in your case also. So we need to start developing that use cases to make sure that we are getting into the problem and we're socializing enough. We're talking to like-minded people. We are hearing to talks. We are hearing to similar industry people and keep socializing with them on a professional scale. So that you now have an idea. Now every idea has a diffusion curve and the way it diffuses. So on the left hand side of the screen, that you would see here is basically an idea creation curve. What idea creation curve means is, now imagine a simple problem that forget about startup for a second. Everybody has been in lockdown. Now each of us is either craving for good food that we are missing. We are missing our favorite holiday destination that we plan to, we were not able to go. Take that as an example for some time and start thinking. Now, if you have to go to that level, and you're sitting in a group of 10 people within amongst your friends, family, or classmates, and you start discussing that, okay, what's the first place I want to go as as soon as the we have leverage to start traveling again. What you would think is, as the time passes by and when we are ideating for this destination, the first idea that came are of high quality, they're very relevant, but they won't be novel. They are the obvious places you would have gone. They are the obvious people where everybody would like to go in the vicinity. So they're relevant. They are qualitatively high. They're good places to go. But then we always think, let's go and try at some new places. Let's try something new, places. And as passes by, within the next few minutes, you're thinking, every obvious idea has been spoken about, and now you're running out of ideas as the timing is passing by. Do not give up. That's exactly what happens when you're ideating with the startups or when you're ideating to solve a problem. What you would realize is if you keep brainstorming, after a certain time, you would start heading up towards novel ideas, which may or may not be relevant exactly as the obvious solutions were. But then they're, good. They are worth exploring. They're worth trying. So that's what you need to do when you are, doing the ideation for your startup. What you also need to understand is on the right hand side of the slide, you would see the law of diffusion of innovation. Uh, with this curve actually suggests us that, okay, how do any innovation that comes in market, be am I as a consumer or be I as an innovator? I need to understand that most of the population or most of our consumers will fall under this curve. To make recall the days when the touchscreen mobile phones were to come in market. Now, if you recall a decade back, or at least that's what the case has been with me. Our parents used to say because we never had that money to buy phones. So way back in colleges, used to ask our parents that we want this phone. Now there has been always suggestion that do not go for touchscreen phones because what if the screen is damaged, the water falls on it, this touch screen start doesn't work. And our parents used to say go for keypad phones a lot. And this has been the challenge if you retrospect a little. Now, how companies like Apple or how companies like later on like Samsung catched up, or especially Apple, so to say, they understood this problem and they wanted the innovation to slowly diffuse amongst the people. A lot of phones that came in at that time, except Apple, was having both the interfaces, the touchscreen interface and the keypad. Remember, very phones we used to have. The purpose of that was to make people aware, make people understand that okay, they are the first risk takers people. They are investing a huge amount of money into new technology. These are the 2.5% of the population of people who spend more money to get new technology because they're risk takers. You always need them as your customer, especially if you're doing something hard. Then what happened was slowly once four or five people felt happy with the experience that they had. Slowly, more people after seeing the first, say two people amongst 100 starting buying the same, technology. The market was changing. All of a sudden, you see that keypad, went away from the market. What all it was, a touchscreen that was left. Then the early majority, that is about first half 50% of the population started going towards the touchscreen phones. And later on, as the time passed by, most of the people started adopting touchscreen. Now, if you want to order something on a key
Sir, I think we lost you there.
Sir, your voice is not audible, sir.
Hello.
Yes, sir. I think we lost you for a few minutes back there.
Oh, okay. I'm so
Yes, sir.
sorry.
It's okay,
Yeah.
sir.
Okay.
Thank you.
Right. So, uh, okay, let me just give you a quick summary of what I was talking in the last 2 minutes. So I was telling about the right side of the curve, which was on the law of diffusion of innovation, and I was telling with an example of the e-commerce industry that when touchscreen came into the market, what happened was, or when e-commerce came into the market, what happened was we were very afraid. We were not buying online. We wanted to, still go retail, and now after 10 years, what has happened is we have especially in COVID, we're just ordering online. We're not even buying it from the stores near us. We think it's good to have it delivered rather than us going out due to COVID. And our parents, especially if you look at from their perspective, they are now ordering via e-commerce website on a touchscreen mobile phone. Both of are the examples which 10 years back they asked us not to use for X, Y, and Z doubts that they have. Right? So that's what the diffusion of innovation curve, and that's what it will happen. Now, going further, what I would also like to share is so there are three I's that would happen for any that would happen. The first is idea, the second is IPR, and the third is the commercialization or the industrialization of that innovation to the market to earn the money back. So that's what we wanted to basically, earn and learn about. And right in the intersection of it is a very successful product, and that's what startups is all about. Now, there are various ways we could use the output of an R&D. For example, what we do is in our college time, especially if you are from college, uh, in India specifically, I would say what we have been told is if we are doing some R&D products, what we need to do is we need to put that R&D out in the space so that people can learn from it and people can read through it. So what happens is that you could put it on journal articles, you can put it on newspapers, you can put it on YouTube channels, you can write books about it, you can do blogs about it, you can put it on social networking. Something that we should never do is just put it on a journal. I'm sorry, just put it on a thesis, print out 30 pages, submit it for grading, and forget about it. So that's something we should never do, and we should never try about, and we should always see that we should get some monetary benefit out of it, which would mean that patent is something that we should always try and go with when it comes to the IPR industry. So that's a question now. Consider it as a jigsaw puzzle because most of us would like to do everything. What's the first thing you would like to start with? What would you like to go ahead and do first? Would you like to go for patent first? Would you like to put it on newspaper first? Would you like to go for Facebook first? And if there are some comments, I welcome comments on the chat window over here. So if somebody would like to give us a quick idea, especially in the chat window quickly, that what should be the first order? What is the first thing amongst the options that you have on your screen? What would you do first? So I'll sip some water in the meantime. If somebody has some suggestions, please feel to put it on chat. Like what should be the first thing we should do amongst that is on your screen? Okay. So Okay, so I've got one answer which says documentation first, but documentation in what form? Documentation could be a literature also, could be a patent also, could be a blog also. Okay, so let me answer that. So the first thing that you would like to do is always try keep it uh, in the form of patent. then go for research articles. Fame is something everybody wants. I've seen a lot of universities, especially a lot of startups today. Once they do something, they just want that it should hit to newspapers, we should get our names on the papers, and we always want to do that. However, that's not a correct approach. And I'll tell you a story. I had a friend from IIT, and they were working on something known as robotic arms. And what happened was they had this technology in mind and they wanted to protect it. Do about it. So what at the end they ended up doing was they didn't file a patent, and 2 years back, 2 years after they thought that the startup won't work, they got a call from Flipkart, and Flipkart made them an offer at that time that they wanted to buy their technology, but since they never had patent for it, and that leaves a scope of insecurity amongst people, and they were feeling a little bad about it that they since they had the technology to protect it, so they're feeling vulnerable to get copied from a giant like Flipkart. So that's the importance of patent. You should always have a technology before you start for funding, before you start commercializing it, so that others do not copy it. Okay. My voice is clear now. Just wanted to make sure that you can hear me well.
Yes, sir. Your voice is clear.
Okay. Okay. So next is, how do you choose an idea? So very quickly, for any startup that we work with, this is how you can choose an idea on a scale of impact versus the time we want to study an idea. So what you would do is something that is taking more time, but it has also has a high impact. They're good for long term. Do not start it right now. Something which uh, is gonna take more time, and it's also of low impact. That is something you should absolutely follow right now, because you do not have money as a startup to keep investing on something which is time consuming, and it's going to take more time as well. And something which is low impact, less time should not be on your priority. There could be additional tasks, but you can keep it on low priority. What is most important is for you as an CEO or as a founder of a startup is high impact ideas, high impact solutions, which you can develop very fast. Is that what you want to start developing upon? So always go for such kind of ideas, and that's where the major part of your investment and time should go. That's what I would suggest. So let's very quickly understand what are the key ingredients for a good research. So there could be many. So these are some of them. The idea has to be novel, especially if you're going through a new technology. You should have done sufficient experimentation, prototyping. It should have application area, wide application area. It should be ready to face up the current competition. It should have market readiness. So these are some theoretical factors that are considered as good for startups to go into the market. And these are some free tools. Of course, we will not run the demo today, but probably if you're taking note or you can just screenshot it. These are some of the free tools that are available for you for the IP perspective. That just do not Google your idea to validate it. Go to specific Google websites like Google Patents or Google Scholars to ensure that you should read where the actual the data giant are. You should just not Google about it. So that is what you should be looking at. Then Science Direct is something for journal articles. eSpaceNet is something that you could use for considering prior arts. Now there is obviously a question. A lot of people ask me that why should we bother if we want to do a startup in India? If our technology is in India, why should we care about something which is there in US or something which is there in Europe? So to answer that question beforehand, because that's a frequently asked question, uh, when patent laws or IP laws suggest is if you want to get a patent even in India, you need to get it proved that you are novel enough, or the prior art that laws consider is cannot be just Indian. It has to be a worldwide prior art free innovation. Okay, despite this grant that you would get or the protection that you would get would still be national. However, it has to be prior art free internationally. So that's how the examiners in patent office would be seeing it. And I would suggest if you can still not afford, let's say, a commercial level, prior art research, to validate your ideas, at least go ahead, use this free search tools to validate your idea and ensure that something is not getting close to you, especially if you are going for patenting a innovation, and it is critical bread and butter for your startup. Okay, so this is how I would generally track it, and this is what I use for a lot of incubation centers that I guide, a lot of US universities specifically, where a lot of young preneurs are working. So we give them this metrics where we tell them about the problems on one axis, the solution on the another axis, and the bubble size that you see on your screen represents the number of solutions already available. So bigger the area of the circle, which would mean that more are the solutions available to solve that problem. So clearly, the less explored areas are the one where you should invest your R&D money into, your time into, so that the competition is less, the market is still there, and you could get your patent there and you could start commercializing there. So that's the kind of effort you need to do before even you start working. It's all in preparation of that, so that when you start putting your hard-earned money or hard-raised money into an invention, you should know that you are filing it at a putting it at the right place. Next is IPR, and probably people to go on their chat windows if you are on WebEx or on YouTube, and we would like you to start answering some questions from the next slide. But in preparation of that, let me just give you basics, especially for whom IPR is pretty new. So this is the entire umbrella of IPR. So there are patents, there are trademarks, there are copyrights, there are geographical indication, and there are industrial designs. Patents is something which is given for novel areas, and so it's like jugaad. If you understand what is jugaad in Hindi, jugaad is like some problem that I'm facing right now, and I want to solve it in an innovative way. Now, this innovative way could be coming from a multi-million-dollar lab, or it could come up from your kitchen. Doesn't matter. It has to be something novel solution that you're giving. So all such solutions which are solving certain problems generally fall under the patent category. Trademarks are basically logos. Trademarks is basically the logo. For example, in the PowerPoint deck, you see Signicent's logo at the top right hand side of the screen. So that these are the trademarks. The jingles, like for example, I am loving it. For example, now if I take what brand do you recall when I say the word I am loving it? You would say that brand is McDonald's. Now, if you can recall that or connect to that, that's because that's a brand power. The jingle is trademark. The punchline, so you say is trademark, and it helps you associate with the brand. And there are multiple examples that you would realize are there by listening to even music, some tones from Britannia or other companies. You could realize that okay, this is something which recalls me of this brand. So that's the power of trademarks. Copyright is given for content. Copyright is given for say the articles that you're writing, the poems. If you're a poet, writing some poetry, writing some stories, so that is content that goes under copyright. If you are an artist, if you are doing some theaters, the content that you get under is copyrighted. If you are a painter, if you are painting something, that is going under copyright. If you are a software coder, the software code goes under copyrights, and basically all such things are going under copyright. Geographical indication is something very easy. Geographical indication is say some cities become popular for something. For example, if I am in Chandigarh right now, in Punjab, you have a lot of sarson ka saag and roti, and then that particular part is what Punjab is known for. Or there are other important things you might have heard about. Amritsari chole bhature and things like that. So cities become popular. Kolhapuri chappal, mangoes are famous. Assam is famous for tea. So these are the geographical indication. It's a group protection that the entire area gets, and that is what under falls under geographical indication. Industrial design is the designs that you would have. So it's basically designed for integrated circuits, or they're on the aesthetic sense. So if I have this mouse that I have with me, if I just have to talk about the shape of this mouse, that's gonna go under either a design pattern, but if we talk about the entire technology that is making this mouse work, that would go under a patent. Okay, so patents, trademark is for brand, geographical indication is for area. Now let's ask and do some quiz with the people who are attending this on YouTube or on on Cisco WebEx. So I'll request moderator if you can give me some idea. So what's the first thing that you have on your screen would fall under? Could somebody guess it on the chat, please? What's the first thing that would come under? What kind of protection is it? So the first thing that would come under is trademarks. What about the second thing? The second thing we have it. Okay, so we got some answers from Saurabh and Shashank. So yeah, the trademark is right. What second thing? The second would fall under. So this is a novel from Chetan Bhagat. What would this fall under? Copyright, that's correct. All right. So if you want to put it quickly, just put the first two alphabets and I'll guess it. Okay. What's this thing? So what would this go under? The secret formula of Coca-Cola that we've been drinking for so long. So this will go under something known as trade secrets because they haven't been disclosed. They have not protected with the form of patent. It's much like what yes, trade secret. That's correct, Shilpa. So you've got your answer, and then this is a small device which is used to, for example, sharpen the mustache over here. So small device that you see here. So what will this fall under? So yeah, so this could actually go under a design. Had it been just a design, but since it's solving a particular pattern, let's call it as patent because it is having a mechanism to do that. Yeah, so patent should be a better answer. Next, let's go further and okay, I'm so sorry, my screen got froze because I think I connected it two times. I should my yeah. Okay, what about this thing? This is a painting. What would this go under? The painting, copyright. That's correct. So somebody has actually started writing the first alphabet. I'm glad that all of you are listening. And then the next thing would be this phone. Now, this could have two angles. Patent, yes, if you're talking about the entire technology, and if you're just talking about the aesthetics, it could go under design. But yeah, patent is good. What about the logos of a company like this? Trademark, that's correct. And let's go. So, what about this basket which has some holes in it? This would go under design patents. What about this logo of a very favorite and popular company these days? Patent. And which company is this? Trademark is right. Which company is this? Logos from Tesla. That's it. And this chappal that you have on screen, what would this fall under? GI. So we have an answer on that as well, multiple correct answers. And lastly, the bicycle that you have in your screen. Design or patent once again, depending upon what you have. So now you've learned what has happened is in the next last 15-20 minutes you've now learned about IP that you need to know. So if you're a startup company, you would understand which part of your company is deemed for what intellectual property. If it's the logo of your startup, it should go to trademark protection. If it is about your technology, it should go to patents. If it is just the aesthetic sense of it, it should go to design patents, right? And if you're writing some software codes or you're doing a paint as an artist, you should go to copyrights. So the funny thing is when we used to ask people who have not known about patent is they say, I want to patent the design and the trademark of the copyright. Can you do it for me? So that's what we generally understand or hear from a lot of entrepreneurs, which is okay because IP has not been a formal course in colleges and universities, which I really recommend, and that's what we're recommending to a lot of IITs today. and universities to have it at the college level. And I'm thankful to institute like AIM and CPAM for giving this as a primer to all of you to learn a little on the IPR. So why safeguard IP? How is going to help you, in the long run? So of course you can do a lot of selling, you can do a lot of royalties, earning. Royalty is something that okay, let's understand this way. Now imagine that you have a startup, you have patented your idea, you've trademarked your logos. Now you're an IP ready startup, so to say. Now, how do you want to earn money? Either your startup is going to do that yourself, or what you can do is if you have good IP, you can let other companies to manufacture it. Generally, you earn 10% to 15% royalty on every unit. So if you want that, let's say if you're working on a sanitization bottle, sanitizer bottle cost 100 as a cost price, you can tell that every 10 rupees or 10% that you make on that sanitizer bottle should come to me because I own the IP. So you could actually earn that royalty. You need not even manufacture sometimes yourself. If you have the IP, you can just earn from the money on the royalty that you're getting. And 90% it could be left to the people who are using their distribution for marketing, their human resource and machinery for manufacturing things. And of course, a lot of people understand it's a recognition thing. A lot of universities and uh, uh, companies today make the appraisals based on the patents that are coming up from a company. So it's kind of becoming into recognition, and I'm glad that probably you get tax benefits also. I think these days on income taxes when you file your ITR, especially if you have patents. Probably check it a little up. I thought that I've seen it. Commercialization is something that could be very handy. One more FAQ here. When I talk to a lot of startups, they say we want to go to an investor, and of course, before we go to investor, we do not have a patent yet, but they want to listen to the idea for us to raise the funds. What should we do? Because if we tell them, then they could copy our idea, so we are too scared. And if we do not tell them, of course, we do not even get our first, money, seed money, or they do not even will listen to us. Is start signing non-disclosure agreements. NDA is something you can Google about. You get some formats. Make sure every conversation that happens, if you're not at the stage of patenting right now, you can always file a provisional application. Provisional application would mean that if you are about 20, 30, 40% ready, and you think you have another 12 months and you will be able to complete it, file a provisional application. You have good 12 months to file the complete specification, but you get a priority from the patent office that if somebody comes from the same idea tomorrow, you will get a priority above the other companies that could be doing the same work. So if you are not even ready for the prior provisional application, go ahead, file at least non-disclosure agreements to whomsoever you're disclosing the area, and you could always do that. Next is it of course would happen in the it will of course help you in the technological development of the product. It will help you in licensing deal. It would help you in the economic growth of the company. And for those who have not seen, this is how an Indian patent looks like. Of course, you can read a little more about it, but this is how it will look like, more or less. It has the title right at the top here, as you would see. Then it registration codes, the company that it belongs to, the inventor names who have worked, and a little abstract. So this is the first page, as to say, and the patent document could be somewhere between 15 to 20 to 30 pages in most cases, which has claims in it, which kind of defines what's the area that you would like to protect. Okay. Next is once you have the patent done, now you need to understand what's the value of my patent. Why it is important? It is important because for most of the cases, let's say if I want to buy a piece of land today, now in based on the locality I want to buy the land today, it has a square yard fee. It could be say 15,000 per square you know, rupees per square yard. So it's a fixed rate which you can multiply to the total area and you'll get some value. This is how you calculate it. If you want to sell your mobile phone which is too old, you would have an idea that okay, I want to start negotiating at 15,000 because if I do that, at least I'll get 10,000 on OLX or any other website. What do you do with something as intangible as patent? So it is not a product yet, it is a patent, but it has huge amount of value. Or you want to use this patent to show it on your audit books. You want to increase the valuation of your company or your startup. You want to say that this is what is the worth of our company. So for IP audit purposes, for telling it to your investors that okay, this is the value of my technology, to calculate the risks that tomorrow if somebody steps onto your IP, how do you calculate damages? What's the amount you should tell that okay, just because you've made copy product of technology that I own, I sued for dash crores. What should be the dash? All this are the things that you would get if you only have valuation of your patented thing. And there are multiple ways. So valuation is never an exact thing because you cannot always measure it. It's a good estimate. It comes with experience. It needs a lot of financial modeling in addition to modeling to calculate that. We will not of course go to the entire it. I have some talks already on YouTube if you would like to understand how to calculate valuation in more detail. I just cover it in the thorough, but we could take that. So valuation of technology is what you need to understand here. There are some questions coming. I'll take it, in the next 15 minutes, so you can, keep pinging it for the report. So there are, two ways, important ways to do it. One is a quantitative way of doing it, and one is qualitative way of doing it. Qualitative way of validating is, for example, how much my patent is prone to get copied. For example, if I have to replicate your technology, are there similar products available which are not exactly the same, but they are solving the same purpose. So that basically is in a space where there are four solutions already available to solve a particular thing, and yours is fifth. Then customers have more options, and they won't just go for yours. So you do not have an exclusivity. Of course, their patent could still be there because you're going via another route while they are coming via another route. But since the last point is still the same, customers have choice which way they want to go to. Other way is how much legal strength your document has, the claims that has been drafted. So this is another thing. We are currently, for example, working on a lot of COVID-related technologies, and I'm glad that one of the Bharat biotech that is coming up with the vaccine, or at least is getting closer to the vaccine. They are associated with a US university, and we've been actually working with them as a innovation partner of theirs for US university, which is then dealing with the Indian companies. And the way we are doing that is because we know that we're helping them validate, we're helping them getting an idea that, okay, this is what you're validating. By validity, what I mean is you should make sure that it is becoming prior art free. It is, you've done good prior art searches, you've searched on, good databases, and you know that nothing like that ever existed. Okay. And if you can prove that, that increases the chance, that increases the value of your technology, that increases the valuation of your company. And that's how, the more or less the qualitative analysis would work. Of course, we can go into a little more detail. It could be coming up with another session of a couple of hours altogether. But I wanted to give you some, drops on that. While quantitative analysis is you need to put an exact dollar value of the technology that you're working in. So there could be cost-based methods, there could be market-based methods, there could be income-based methods, and you could, always look at these methods in detail. And then is licensing. So what happens is once you have developed the technology, you've done the valuation, you know that okay, my technology is worth around, let's say, $100,000 right now, which is roughly about say 7 crores, 7.5 crores right now in India. So that's the technology worth that I am having. So what should I do now? Is I want to start manufacturing it myself, or should I give a license? A license could be of many types. It could be an exclusive or non-exclusive licensing. Exclusive licensing would mean that my startup has developed something, or my university has developed something, and I just want to give it to one company, assume Mahindra and Mahindra. So you want to give your technology to just give it to Mahindra and Mahindra, but not to the other automobile companies. Non-exclusive would be something that you wanted to give it to multiple companies. The same technology could be used by Mahindra and Mahindra, Ford, Maruti Suzuki, or any other such company. And the royalty amount accordingly, the percentage that you would charge them would obviously be more in non-exclusive licensing. Exclusive licensing, why it more is because that's a single source of money right now. So if you're giving a 15% royalty deal with exclusive licensing, probably you can drop it down to 7-8% in non-exclusive licensing, and then give it to five people, so that at the end you're earning a little less percentage, but from five different sources, right? Then there is compulsory and voluntary licensing. Compulsory licensing is government could push you that if you're working in an area related to COVID technologies, you develop vaccines, you develop medicines, which is important for life-saving drug for everybody. Government can say you have to do a compulsory licensing because you cannot match up to the volumes of people. Demand is too much. We want to save our country from death. So that's something where government can push us towards compulsory licensing. Voluntary licensing is a very good, kind-hearted person and say, use my patent for free, do whatever you want, and you give it voluntarily for licensing to every manufacturing company that approaches you. Cross licensing is a kind of barter system. I give 5 patents, that company gives in 5 patents, and each of us uses each other's patent, and we kind of cross license it, and we both use without paying much royalty on either side. Carrot and stick licensing would be something which would be important you to understand. So carrot licensing is, say if I as a startup have a patent in the sanitization area, and I want that there is an existing company, let's say Johnson and Johnson, who's making certain sanitizers, and I want that if they use my particular dispensing device, their sales would increase. So you're giving a carrot to increase the sales. Okay, so that's an advantage. They are the technology things which adds value to an existing technology that could help drive the sales more. So that's more of a carrot licensing model. Stick licensing is, that there are companies out there who are copying your product despite you have a granted patent already. Then you have a stick in hand, guys. I'm going to take you to the lawsuit. Better start paying me the money right now because I own a granted patent. I send you reminders. You are not giving me the royalty. So I have a stick. So that's the kind of enforced licensing amount that you could ask from litigation perspective, and you could gain that. And finally, in a typical licensing agreement, the licensee would have an access to make, have made, use, export, offer to sale, while the licensor would have to pay the fee, the payments, the royalties that they would earn, and that's how it would be generally going about. So just to give you very quickly an idea, such a licensing deal. So if your startup chooses to go by licensing model, decide on the royalty, confidentiality, for what term you want to give the license for, who would maintain the patent in the long run, what if something bad happens, the infringement happens, or the patent doesn't stand and it gets invalidated because it loses power, who will bear that liability, what are the disclaimers, and who would pay, are there any insurance clauses that you would like to damage. So all this could be part of a legal agreement that you would go. So towards the summary, as a startup, validate your idea, file a patent, wait as you wait for it to get granted. You could do your market research, you could start your manufacturing, and you need not wait till the grant before you do it. You could start it from the day one. But then if it happens in a grant, you get exclusive right, and you stop others from making, using, or selling it. So that's the beauty of IP in there. Get your patent valuation and market research done. Go for licensing or start manufacturing yourself as a startup. So these are the entire breadth of key considerations as takeaway from this session, that you could go towards patents, go towards literature, products, market strategy, understand the regulatory perspective, and then decide for the commercialization. So yeah, so that's about an hour of 60 minutes, 50, 60 minutes of what we had for today. And of course, I'll be happy to take any questions now, that have been put in there on the chat.
Right. Thank you so much, sir. A very informative and a very engrossing presentation. We do have a few questions from our audience from here in the meeting and some from YouTube as well. So I'll just moderate those and I'll ask you. The first question that we have is, what are the various support given to Indian startups for filing patents for Indians and even in US, and any financial support provided to them?
Well, yes, you can actually. Government these days are giving supports. For example, what I've heard is, there. If you go to Startup India website, register your startup there, and you just need to pay some very nominal fee for startup. I think the fees is about 2-3 thousand only for filing the patent. Of course, drafting depends if you do the draft yourself or do you want to get the draft commercially. That's something that you may like to consider, and the fee may vary. So register on that website. take advantage of it. Generally, there are names of patent agents which are authorized from the government side. You can approach them in your locality or the nearest to you. They get, I think, paid about 10,000 to handle your case. Personally, I think 10,000 is too less for somebody to get compensated from the government side, because that's not worth the effort that will go into writing a good patent. But in any case, if that's something that you would like to go with, you could go around that and get the patent filed via such government agencies at a very reasonable price.
All right. Thank you, sir. Another question that we have is how should a startup balance enforcing IPR and the legal costs associated with it?
I'm sorry, could you say that again, this last part?
Yes, so how should a startup balance enforcing the IPR and the legal costs associated with it?
How somebody should balance it?
Yes, sir. The cost between how should one enforce an IPR and the costs associated with it?
Okay. So you have to bear the cost by yourself. Unfortunately, nobody's gonna give. So that's something that you have to find out your money from, especially while enforcing. Enforcing is considered as, of course, costly process, especially in US. People want to have out of court settlement. You do not want to go into litigation. But if it happens, you have to bear the cost, of course, because it's your patent, it's your technology. It's like, it's somebody's, it's your own child, and if it is getting kidnapped, of course you would do everything that you would do to get your child back if it is getting kidnapped by somebody bad. So I don't think it's the same analogy here. If somebody's gonna step onto your IP, you would have to bear the cost. You need to enforce them, you need to send them legal notices, and get it stopped, and whatever cost has to come. But gradually, since it is going to help you in sales, you will become the sole player in that area. I'm sure gradually you'll recover that with the increased sales that you would get, because the copied products won't be there in the market.
All right. I hope that does answer the question. With a developed market for selling patents in India, what about price discovery of patents and other IP?
Okay. So developed market in India, no. Uh, it's very difficult. I did a session with NRDC in Delhi year back or so. I have a talk with NRDC, which basically deals with a lot of government institutes, at least, including the premium one, to help them sell their IP. I was not probably, what should I say? I think there is a lot somebody could do. There is no systematic way. Some of the tasks that, for example, Signicent does, the same way that you are asking for US universities is, I'll tell you what we do and probably see if you could do it at your end. Uh, get the patent, validate it, make sure it is free, make some pitches to the manufacturers, see if they're interested, quote a value, negotiate upon it, and see if you can get the deal done. That's do it. But if you will say, is there a way out, a systematic way? No. Most of the universities today, especially US universities, have a tech transfer or a licensing page on their university websites, where they tell that these are the patents available that you can license in. So if you're from a student perspective, you're asking from a student perspective, or if you're from a university, go back to your university, tell them to at least start making a web page on their website where all the patents that are coming from a university could come up, and people at least will start surfing and they may reach you. That's like a very difficult way. I think it has to ground. You should start making phone calls, talk to them, identify 15 good companies that you want to go with, and then see if they pick your calls, if they can negotiate, or how do you want to do it. Or else you could always hire a IP company, pay them the brokerage and a small setup fee, and then they would do all the the dirty work for you. So that's how it generally would go.
Thank you, sir. The other question that I can see from the chat box is how does one evaluate a patent?
Could you elaborate, like, if you think evaluate a patent from, if it's your own patent, if by evaluation you means you want to validate how strong it is, as I said, that evaluation will be done on claims analysis, which would again in simplified terms mean Go to Google Patents if you do not have access to commercial databases. See if some patent from US, Europe, India, China, or whatever country is coming very close to you. It's like your invention is looking like a replica of what somebody has done in those countries. That's gonna throw out the valuation of your patent to lot low. That will increase the chances of invalidity of your patent, even if it is granted a little longer. So prior art researching or prior art searching is something that would make good comment. And if you mean by evaluation the money value, so then I've said use cost-based, income-based methods or market measure. You could look for deals that have happened in the similar area before. So if I'm in say autonomous vehicles or yeah, I'm into technology of driverless car. I could see what is happening in the driverless car area, what the deals looking like, and you could match up the value.
Thank you. We have Miss Silpa. She had asked this question. Ma'am, does this solve your query? It does. All right. Thank you. Another question that I see from the chat window is this: in case of a co-patent, if one party wants to go for a patent of addition, how is the share of royalty decided in that case?
Okay, you have to talk to your partner. Personally, I haven't had an expertise in area, so what I'm telling you is more logical than a legal way. Go and talk to your partner. This is something that you need to talk to the co-inventor beforehand, and strike out a deal that okay, if you're leasing, I'm sorry, if you're leaving it, if you are not interested, I am interested in it. This is how the royalty sharing would be done. You have to figure it out, with that inventor. I think legally, I'm not sure if there is any, but for my knowledge, there isn't any calculated formula that how much royalty who gets. Maybe you divide it equally, maybe you divide it a certain percentage way. It all depends what you have, discussed amongst yourself. If you haven't, probably you can now go and do it. And accordingly, if you would like to, invent more, you want to continue the work in that area. For the next areas, I would like to, since I'm putting my own money and effort, so I would like to, take more share because it is more of my efforts than yours. So yeah, something of that sort has to happen amongst yourself.
Thank you, sir. I think there's another question, and you might have already answered it, but if you want to just add anything specific there. So the question goes, if is there any government support for patent filing, both domestic or international patents, that any incubator can use for its
Uh,
startups?
I mean, for domestic filing, yes. For international patents, I haven't heard. International patents costly. Generally, people for PCT route start with WO. PCT applications is what generally people would file, especially if you want to go for multiple countries. The cost could go, in $1,000 or so. And of course, if you have to hire a foreign law firm, the cost will be a little more. But for national patents or Indian patents, yes, as I said, you could go to Startup India website. There are list of people from with whom you can get this work done, and the startup fees are already very less. I think it's 2,000 or so for government fee for filing.
All right. Uh, One more question that we have is, can an incubator submit patents rather than the startups? Are there any funding options for this?
Yes, I mean you can do that, but does your incubator invent? I think the startups would still be inventing. Uh, this is more of contractual thing. Make your startups have a share. For example, uh, uh, if I want to go with a incubator for my products, they would generally ask me 5%, 3%, 10%, depending upon what kind of incubator you are. So you could always have a share. So this comes with an internal document. You could file a patent actually, but if the inventors are startups, people, it won't be legally right, I think, because if they are inventing, I cannot be a signee, but I could be coming as a co-assignee. That would, and as I said, the distribution of profit or the distribution on revenue is something that you need to agree with your startups if you are an incubator.
Right, sir. Thank you. I think we've covered most of the questions that were there. There's one more, sir. If a technology, when run via prior art, is deemed to be disruptive in nature, how and when an entity shall approach for valuation of the patent?
Could you repeat that, please?
Sure. If a technology, when run via prior art, is deemed to be disruptive in nature, how and when an entity shall approach for valuation of the patent?
So if you say, so what I'm assuming is you are saying that it is disruptive in nature, which would mean that it has come prior art free, right? And nothing like that ever existed before. And you're the first one. It's very difficult to get a valuation then. That's a challenge actually, to be honest, because if you're creating a very new vertical where nobody in the world has worked ever, and it's totally disruptive, it's very difficult to get a valuation, and probably you need to just put in based on the forecast of your sales, that if you think that it's gonna get billions in the next decade, so you could keep your valuation based on your futuristic sales, and convince an investor or somebody that this is what I am perceiving, and it all depends if they buy your pitch and agree to that value. But it's a valid question. It's very difficult if it's a technology which is into a completely new space and nobody has ever worked upon it.
Yes, thank you. Last question that I'd like to, ask on behalf of the audience is, what is the success percentage of patents when filed without a patent attorney? Any data on that?
No, I haven't come across any data. To be honest, there could be, there could not be. Uh, what I would have given you as a comment is, see, uh, if you're right, if you're just gonna write one patent ever for your startup, or at least one patent ever, and your entire startup revolves around one patent, and it's the bread and butter your entire next 10 years of work, you will be investing money, time, sleepless nights. To not be miser in spending and writing a patent, and thinking that I can do it. Of course, you can do it. I'm sure, despite not being a patent lawyer or patent attorney, you could write it. But then it's like saying that I can repair my entire pipeline of my home, though I'm not a plumber. The risks are always there, and you need to weigh down. And that my suggestion is, do not risk it if you are just relying on that one patent for the entire life of your startup, and of course your career and your livelihood.
Okay. Thank you. So we're receiving a few more questions, if that is okay. Can I go ahead?
Yeah, go ahead, please go ahead.
Thank you. So what are the typical charges for filing a PCT?
Depends on the country. Just Google it. I think just Google it. Which countries you're interested in? What are the files fees of those countries? You can initiate it in India. That won't cost much. You could get it searched in India. That won't cost much either. But when you are gonna get it examined and get it granted in other countries, that's what is gonna cost much. We handled a case, for example, one of the Delhi-based company approached us to have some practice in South Africa. So we talked to the associate law firm in South Africa. They said about $4,000 is what they're going to charge. So we passed that bill directly to the Delhi-based company who wanted to South Africa. So it's entirely estimate based. I cannot give you one figure that would work for all. Every country has their own prices, own documents, and which countries are interested in. Just Google it. It's like very standard. You'll get it easily. And the law firm charges would generally go between 1,500 to $2,000, depending upon more or less which countries you want to go.
All right, thank you. Another last question that we have, sir, is what is your advice, and what is one thing that any startup should keep in mind while they're filing a patent?
What is the? I'm sorry.
What is your advice, and what is the one thing that a startup should keep in mind when they're filing a patent?
Okay, so advice is do it as fast as you can. Do not waste time. Uh, uh, you never know how many people are running the same race in their respective labs or startup. So you want to get that first mover advantage. That's the most important piece of advice. Second is if you are drafting it on your own, uh, understand some how to write claim. No matter what you write in description, title, abstract doesn't matter. Claims is something that is going to give you the entire the power to the patent. Make sure you write the claims or you get drafted the claims in a way that they are very strong, they are broad enough to cover a good ground uh, from both perspective, from defensive perspective also, and from offensive perspective also. You do not want others to step in, and if they step into your IP, you can sue them. And of course, you do not want that you should lose the race, and you do not want the competition to enter into the same space you are in. So that's the kind of balance you need to make while you are drafting the patent. And yeah, so that is what I would suggest to startups to consider when they are drafting.
Yes, sir. I agree with you there. Thank you, sir. I think we are done with the questions, and especially the last 20 minutes, they were quite informative.
Sure.
So I'll just like to thank you for your time and effort for this very instructive, illustrative, and very illuminating webinar today. I'd also like to thank our audience here and at YouTube as well for joining us.
And what I would like to suggest is, so I'm just sending uh, my LinkedIn URL to the chat box now. So if you have more questions that you would like to ask, of course you can connect on LinkedIn, and we can of course keep it beyond this session also if you want any kind of help in future. And thank you everyone for joining, and special thanks to AIM and CIBM for having me here.
Thank you so much. We greatly appreciate your participation.
Thank
Thank
you,
you.
and you are
Thank
a
you, everybody.
wonderful moderator. Thank you. You are a wonderful moderator. Thank you so much.
Thank you so
Very
much, sir. Thanks.
bye bye.
Thank you. Thanks.